up to $1,000,000. $1,000,000 of assessed value. That was the parent-child exclusion. Wonderful. A house, $1,000,000 of property to my children, and their property tax bill doesn't go up until February 16th. Daniel, the next slide. Starting February 16th. What's this? The kids are moving into the house. What's all this about? If I leave a residence to my children and they move in and use it as their own residence, their property tax bill will not go up to a certain amount. And the limited exclusion is if my house is $1,000,000 over its assessed value, anything over the million will get reassessed. Well, we used to think, oh my God, that protects everybody. Not necessarily so. What's happened in California? We've seen real estate values skyrocket, especially in certain cities and locations. So very restricted now, how much can go to a child, California real estate, without their property tax bill going up. They've actually got to move in. So this has led to some interesting discussions where parents actually do ask their children, you know, if I'm gone, what about this house? What's the plan going to be? And the next slide, Daniel, if I can get it, take out your checkbook. Some people pay still their property tax bill with a checkbook, even though you could go online. Remember the other property? Remember the Capitol Records building that I could give other property, rental property, commercial property to my children up to $1,000,000 without reassessment? That is gone. Everything is going to be reassessed unless it's a residence and the child moves in. So what do we talk about when we're talking to our clients or after a death and we're talking to the executor or the trustee? Let's evaluate right away. What do we think the new property tax bill is going to be on this rental or commercial property? What's going to happen to the cash flow? Should you really hold on to this property, or now this investment is not attractive anymore? Should it be sold? Does it have a new income tax basis, not property tax basis? Does it have a new income tax basis and it could be sold without gain? So now up front, this analysis needs to be made with respect to real estate.
Yeah, so if you've been in our office in the last year, setting up your estate plan, this is going to be one of the questions that we've started asking just very routinely regarding your house is, first off, do you think any of your children would want to keep your house in the event of your death? And so that's kind of the biggest discussion we'll start off with, because if not, if the client tells us, well, all my kids are out of state, they're not going to move back to California, who cares about property taxes? They're just going to sell the house. Great, end of discussion. We don't have to talk about it anymore. But, maybe somebody has expressed interest. My daughter is a single mom with lots of kids, and she would love to be able to live in our house. And my house is going to be much bigger for her, and she can stay there for a long time. And then we need to think about, okay, great. If that's what the plan is going to be, what about your other children? Does the daughter inherit the house? Does she have to co-own it with a sibling? What's the best way to plan around it? Or basically, you don't know. How can you predict into the future whether a child would want to live in the house, not live in the house, own it, rent it out? So we go through all the machinations of what's the outcome of having an increase in property tax bills, especially, again, the only way you can keep it is on your primary residence. So no matter what, commercial property, already rental property, all of those numbers are going to change if you pass away. And it's always good, if you're going to be talking to us, we're going to help you plan, or at least the children kind of think of what to expect, especially after you lose a parent. It's kind of a hard time to make those types of decisions on your own for long-term planning. And so we give our clients just lots of different options to think about what to do within the estate plan today to make it easier or provide flexibility for the children if you were to pass away, and let them decide whether or not they want to keep the house or live in the house. And in the simplest way it could work is, let's say, I die, I have 2 children, I have $1 million in cash and $1 million house. I want the cash to go to my son, the house to go to my daughter. and now they have an equal division of the assets under the trust. Wouldn't that be nice if everything worked out that way? I just want an equal division to my two kids, but they can pick and choose who gets what. So that's what we call a non-pro rata distribution. So it's not like they each have to get half of that cash, half of the house. As long as their shares are equal in value, that'll work. Doesn't always work out that way. What if I have, $500,000 in cash and $1 million house? It wouldn't be equal if my daughter gets the house and my son gets cash. It's not going to be an equal division of assets. The problem is if I allow, or if I don't plan around it, and that's just what's going to happen, and my daughter says, well, how about I'll take the house, I'll get a loan, or I'll pay you off, and now you do get, an equal value worth of assets to me, but it comes out of my funds. Unfortunately, that's considered a sibling to sibling transfer, not a parent to child transfer, because it didn't qualify. My daughter in this example had to use her own money to buy out her brother. And in that case, the property taxes will be partially reassessed. So not great planning, because you could have avoided the reassessment. How would you do that? One option is to include what's called a right of first refusal, or an option to purchase within your trust. So the trust would actually say, if I die, I give my daughter the right to purchase the house from the trust. And in that case, she can buy it from the trust, and it is a parent to child transfer. And now there is enough cash for the trust to now equalize the distribution to my son. And so just giving that simple right of first refusal gives us the ability to plan ahead in case the daughter wants to buy the house out of the trust from the future. And it's not something that we put into every single estate plan. As you can imagine, that could actually cause conflict. And so it's something that we really want to speak with each client about. Again, if they're saying they might want to allow one child to take the house as part of their share, but there's not enough assets to do that. Another way to do it, again, and this really comes up after the death of the parent. So if the house is in the trust and it's just sitting there waiting to be figured out who's going to get what, in a way, the child, really the trustee, can do what's called a parent-child equalization loan. So it's a really kind of specific type of loan that happens within the trust. So the trustee essentially strips some of the equity out of the house, causes the house to be encumbered with a mortgage. So now the net value is reduced. So there's enough cash to pay out to the son. The house subject to the mortgage goes to the daughter. And in those situations, it qualifies for the parent-child exclusion. So that would be something you would do if you didn't have that right of first refusal within the trust. So again, all of this is, to tell you, it's something that we're going to be having to talk, these discussions we'll have to talk about for the foreseeable future. It used to be with the old parent-child exclusion, we never even had to think about it. It was almost automatic that so much of real estate could pass to children that we could just look at somebody's, balance sheet and say, okay, we don't even have to think about it, because the law will automatically provide that all your property can pass without reassessment. And so that the last couple discussion, or the last slide, that really had to do with dealing with property kind of owned in your trust, going from an individual to a child. There are other exclusions from reassessment, not just the parent-child exclusion. And so now we kind of have to be knowledgeable in all these different methods of how to exclude property taxes from being reassessed. So we are thinking about creating like partnerships or LLCs, dealing with what's called the original transferor rule, where two people own a property individually between the two of them. And then it's versus just a parent, even like a husband and wife, but like a parent owning it and then transferring it to a child, whereas maybe the parent and the child own it together. And then there's subsequent transfers in the future that can pass without causing the property to be reassessed. So there's a lot more kind of in-depth discussions we're going to have. And I do see one of the questions that talks about specific to Prop 19 being maybe misrepresented to the general public. Again, anyone that I've ever talked to either didn't remember it or felt foolish after they thought they understood everything, that didn't actually be able to go through it all and understand it. But yeah, potentially there could be a referendum. There are proposed bills out there to either delay the implementation of Prop 19, maybe push it out a couple of years so they can figure out some of the finer details, or just have it reversed or less severe. Again, We'll tell you if anything changes, but so far, this is the law that we're having to deal with, is that new Prop 19. Oh, and Roberta, if you could unmute yourself, that'll help everyone hear you.
Gosh, I feel like one of those people. You forgot to unmute yourself. All right. The Secure Act. This is a law from 2020. This didn't change recently, but people are feeling the effects of it even now, and some people are surprised by it. We're talking about income taxes and withdrawing from retirement plans. So for instance, an IRA. I know if I draw on an IRA, that's income to me, and I have to report it on my income tax return. But what if somebody dies owning an IRA? No great surprise, when the beneficiary draws on it, they have to be concerned with paying income taxes. The income tax liability doesn't just disappear, it passes on to somebody else. And what we're always trying to do is stretch out the withdrawal period on IRAs, even after death, so that the account can grow tax deferred, and the reckoning, the withdrawal and paying of the income tax occurs as late as possible. Well, in 2020, the law changed, and it's worth going over the new rules one more time. Life expectancy is a wonderful thing. If my beneficiaries can withdraw over their life expectancy, especially maybe a newborn grandchild who might have a life expectancy of who knows 100 years under the new charts, that account can grow and grow and grow and grow. And finally, of course, it needs to be withdrawn. So who still gets to use life expectancy, which is called also required minimum distributions? Number one is a spouse. So spouses, you are treated exactly the same as what you're used to. That if you have a deceased spouse, you do a rollover IRA in general and use life expectancy. Who else gets to use the long deferral? Minor children until they are an adult, a disabled or chronically ill person. So somebody with really a permanent disability gets to use life expectancy. And here's the wacky idea: a beneficiary less than 10 years younger than the IRA owner. Well, who's that? That's going to be the IRA owner's brother or sister. So if you leave an IRA to somebody who's within a few years of you, they can still use life expectancy. That's the best of all worlds. What's not the best of all worlds is getting the 5-year withdrawal period. Oops, you thought you had maybe a whole life, but no, the IRS says it has to be withdrawn within 5 years. If your beneficiary on your IRA is your estate, or you didn't even name a beneficiary, there's no excuse for that. You need to name a beneficiary. Or if the beneficiary you named is deceased, or if it's a trust that doesn't have certain provisions called see-through provisions. Those are situations where it must be withdrawn within 5 years. Yes, it gets to grow for a while, but then boom, it must come out by the end of the 5th year. Well, most people fall within the final 10-year period. So if I leave an IRA to my children, they will have up to 10 years to withdraw the IRA, or even a special kind of trust for my children called an IRA trust. And they don't have life expectancy anymore. So they don't have required minimum distributions. They can pull it out anytime during that period, that 10 years, but it must be all out of there by the last day of the 10th year. So that takes some planning, and it's something that we definitely focus on when there are really big IRA accounts. So what's important? Boy, I think every year we say this: check your beneficiary designations on your IRA and keep a copy of the beneficiary designation. So if you have it at, we say Schwab, Vanguard, Fidelity, it's on their form and you're providing them, you're filling it out, maybe online, but keep a copy for yourself. It's so important. It's as important as your will and your trust. And if you name a first beneficiary, be sure to also name a contingent beneficiary in case that person isn't living. And Daniel, let's go to you.
All right, so now we get to move on to some changes in our kind of California probate code. So anytime you see PC on the screen or in the handout, that's the probate code in California, which really rules across all, trusts and wills and estates. That tells us what to do in every situation. And so a big one that changed regarding charitable trusts is going to be starting July of this year. So there's a little bit of leeway for us to figure out what to do in every situation. But this has to do with charitable trusts like a charitable remainder trust, charitable leave trust. So sometimes people will do these advanced kind of irrevocable trusts that they set up in their lifetime that is meant to, make sure money goes to charity, but also reduce income taxes that could be due if you were to sell something. And the new law says that now the trustee must give notice to the California Attorney General's office 20 days before they sell, lease, convey, exchange, transfer, or dispose of all or substantially all of the assets. And so how does this work? Basically, let's say you have a business that is going to go public, or you're going to sell the business. And if you just sell it from your own name, you're going to pay a huge tax on all that gain. Or commonly, if let's say you have an appreciated stock. So maybe you worked for Pfizer or something like that for a very long time. You have all this stock and you're really concentrated in your portfolio, and your advisor says, well, I think you should diversify, but you don't want to pay the tax. People will set up in those situations a charitable trust so that you would put the stock or the business interest into the trust, and then the trust sells the assets. And in that case, you're sort of minimizing the taxes that would be due, because the trust says maybe you retain a payout like an annuity for the rest of your life, but upon your death or after a certain period of time, the balance goes to charity. Isn't that nice? So you're sort of softening and delaying the taxes versus just selling it from yourself. But again, the new law says that when you do that sale, which typically is going to happen when you set up the charitable remainder trust, it's usually going to, every time you're going to sell all the assets in that trust, that you'll have to give notice to the Attorney General's office, which you didn't have to do before. And the policy behind that is, they just want to make sure that you're not doing any kind of underhanded deals, selling to related parties, something where you're trying to game the system, I suppose, so that the Attorney General's office gets notice of the sale.
All right, trustees, another alert. And I think this is the big sleeper in the news this year. We all found out about this rather, after it passed, and it's a little bit shocking. So let me tell you what this is. If you're a trustee and you take over after somebody dies, the law has said for years that you must give notice to the beneficiaries of the trust and the heirs of the decedent that they have the right to see a copy of the trust, and they have 120 days to contest it. And the reason this was passed is the courts got tired of late contests of trusts. They wanted to expedite. If anybody has a complaint, you've got 4 months, come to court and tell us you don't like what the trust says. Now a law has been passed that's effective this January 1st, that if the creator of the trust is still alive, but has become incompetent or incapacitated, the trustee must give a notice to the beneficiaries of the trust, a copy of the trust, saying, here you go, because the creator of the trust, the trustor, can't change it anymore. They've become incapacitated. And the trustee must give annual accountings to those beneficiaries. So you could have someone who created the trust, has become incapacitated, and now their children, their grandchildren, charities, other people are getting notice that they are beneficiaries, and this is what's happening to the trust. They're not entitled to anything yet, but they get to review it all. So is this a good law or not a good law? I think it's good in that if the creator of the trust isn't competent to review the accountings, they should be given to someone. On the other hand, are you going to have beneficiaries who say, don't spend money on mom? The place is too expensive. You could provide care at a lower cost. You're just spending my inheritance. So you can imagine, the unintended consequences of this law. Now, the law says we look to the trust to decide, does somebody have capacity or not? And our trusts usually say if two doctors determine there's an incapacity, that's how incapacity is determined, but other trusts say different things or don't say anything at all. The law also says that this requirement on incapacity can be waived in the document. Now, that's very interesting. If I say to my client, if you become incapacitated, do you want that there are no accountings to anybody? Nobody's watching? I don't know that that's a good idea. Do you want that your trust shouldn't be disclosed to your beneficiaries or anyone else? It's a question. So it is an obligation that trustees have. And if you are, for instance, a professional trustee, you're going to want to review every situation where you have an incapacitated trustor, creator, and you may have to start doing this annually. And Daniel, could you take us to the next slide?
Yeah. So this is the Eifert case. And here we had a 90-year-old grandmother who was very close to her grandchildren after her own children died. And she intended on them inheriting everything from her estate. So that's how she set it up in her estate plan. She said, upon my death, everything goes equally to my two grandchildren. They were also named as the successor trustees as well. So if she became incapacitated, they would be the ones to take over and help pay the bills and manage the investments and file her taxes. So it was a very kind of straightforward relationship and plan. The problem was, in this case, is grandma started to, believe that these grandchildren that she was close with were doing some things that she didn't agree with, like getting into her accounts, taking control away from her. They were going to, shred papers and kind of hide things from her and open her mail and kind of be all controlling over her entire life. And so, because she believed this, whether or not it was actually true, she changed her estate plan to say, it's not going to go to the grandchildren. I want everything to go to charity. They've been, sneaking from me and stealing from me. And so I don't want them to get anything in my estate. And of course, when she died, the granddaughters tried to contest the estate plan. And in this case, the court said, even though grandma was, false in what her belief was, the granddaughters weren't doing anything like that. Still, they did not say, the granddaughters couldn't prove that grandmother, had this insane delusion, or that she didn't have the capacity to make the changes. Even if she was wrong, she still had the capacity. And so it's something to highlight that anytime you make an overall huge change to your estate plan, that sometimes we'll ask the client, do you think the granddaughters are going to get upset about this? Do you want to maybe put something in writing to them, just in the file, to say, I'm making this change. It's in my own handwriting. I sign and date it. Look, I have the capacity to even prevent the conflict. What about in your lifetime? For the granddaughter's perspective, what could they have done differently? And perhaps maybe grandmother should have a better substantiation that grandmother did not have capacity. So maybe take her to her doctor and say, look, this is kind of what's happening. She's being forgetful. She's making these accusations, kind of her mood's changing, mood swings and all these things. Do you think she has capacity? If the doctors say no, from the granddaughter's perspective, that would have helped them, because they would have had enough proof to show that she didn't have the capacity to leave everything to the charity. So again, when you're coming to us, we'll kind of give you all these different pointers in setting up your estate plan. And it's in a way sort of a big red flag if you decide to omit your heirs or make huge changes, towards the end of your life, that we really want to protect your decision. Sometimes we'll even have our own client get a letter from a doctor saying they do have capacity. So again, if you're concerned that it would be objected to, that's a way to kind of settle that so it doesn't get objected, or less, doesn't end up in court.
All right, a picture's worth 1,000 words. This is the Cortez case. On the right, you see grandpa. On the left, you see his adult son. And in the middle, you see his grandson. Well, what happened in this case? Grandpa was leaving everything to his children. I have to say it was 4 daughters. This isn't a perfect picture. And then his grandchild started taking care of him, became his caretaker. And lo and behold, his will and trust is changed. Grandpa says, no longer do I leave everything to my children. I'm leaving the whole thing to my one grandchild, and that is that grandchild who's the caretaker. So the question in this case was, did that grandchild unduly influence grandpa to make this change? Well, the grandchild said, look, we went to a second attorney who gave us a certificate of independent review. And the second attorney said, in their opinion, grandpa is not being unduly influenced. It all went all the way to court, and the court said, you know, that certificate of independent review works when you have kind of a third party caretaker, but it isn't enough evidence where it's a family member caretaker. So again, we have a situation where the court held there wasn't enough evidence that grandpa was unduly influenced, and his estate should go to his children, not to the grandchild who was taking care of him. And I'll give you an example. Sometimes we get a phone call in the office from a child or a grandchild saying, my dad wants to change his will. I say, really? And you're the child or you're the grandchild? And we look to see, have we ever represented dad or grandpa before? Or this is somebody coming to us as a new client, and it's really the beneficiary who's calling us. And we're very careful. And one of the things I might tell that beneficiary is go back to dad or grandpa's estate planning attorney so that there's a history of somebody who used to represent that person making the change or deciding whether there should be a change at all. It's very suspicious when we have the beneficiary contacting us. And a bit of advice to our own clients is, if someone is influencing you to make a change and they want you to go to their attorney, you say, well, I already have an estate planning attorney. Let's go back to my attorney, because your own attorney will help kind of modify what's going on and take a look at, are you really being unduly influenced? Meet with you privately without that beneficiary in the room. So watch out for undue influence.
Yeah, and speaking of undue influence, so not only could that happen between a child and a parent, it could also happen between spouses. So here we're looking at the estate of Wall. And in this case, husband and wife were married. Husband had children from a prior marriage, and they had had all their assets were separate from each other. They did not have a prenuptial agreement, but they just kind of kept their assets in their own name. And husband and wife bought a house. But the house came from husband's separate property assets, and wife couldn't qualify for the mortgage, so she couldn't be on title when they closed escrow. A very common situation where if one person can't qualify, when you go through escrow, they just say, well, let the one spouse be on title, and you could add your the wife or the husband later on. That's easy to do, and it doesn't affect the mortgage. So that's what they did. Husband, bought the house in his name and got the mortgage in his name and told the wife, oh, I will add you on title later on. Don't worry about it. Well, of course he didn't. Otherwise he wouldn't be in this handout in our presentation. So what happened is husband died and he's the only one on title to the property. And so from his children's perspective, they want to say, yep, house belongs to us. It was in his name. His will says everything goes to us. And the wife said, well, I think it's community property. I should get half of it. Even though he bought it with his separate property assets, maybe I put some money towards it. So I paid off some of the mortgage with my funds. And now he kind of commingled it, separate and community property. I should get half of it. And in this case, the court would really look at how is title held, what was the intent of the parties. And normally they would say that the form of title would control, meaning that it really was husband's sole and separate property. because at his death, that's really all they would look at, is how he held title to the property. But in this case, there was additional factors to prove undue influence between the husband and the wife. He told her he was going to add her on title to the property. Maybe he dissuaded her from trying to get on title to the property. And so due to the undue influence that prevailed over the title being just in the husband's name. So again, part of meeting with us, we're always going to ask you, how are title to your assets held? Again, just like we ask you about your beneficiaries on your retirement plans, we ask you, how is title held? Is it in your name? Is it in both names? Is it in the name of your trust? Is it in the name of their trust? Because all of that is going to affect how the property passes. And with real estate, at least a lot of times it's in a way under our control that we can see how title is held, because real estate is public record. We can look it up. We can see how title is held. But if you have a bank account or an investment account, and you didn't bring us the statements, or you didn't tell us how the account title was held, it doesn't matter, in a way, what we say within your documents. If you have a joint account with somebody else, it's not in the name of your trust. It belongs to the two people that are on the account. If one of them dies, it just belongs to the remaining person on the account. So it's really important always to be considerate of how you hold title to your assets. And again, sometimes the largest asset is going to be real estate. And so especially for like blended family or late in life marriages, it would be important that we come up with a plan so you don't end up in this fight between a step parent and stepchildren.
And now we have another title case from this last year, Pierce versus Briggs. Well, a husband and wife bought property as joint tenants. It says that, joint tenancy with right of survivorship on the deed. What does that mean? It means if one joint tenant dies, the property must pass to the surviving joint tenant. What your will says, what your trust says, it's rock, paper, scissors. If the deed says joint tenancy with right of survivorship, that's where it goes. Well, in this case, the wife wrote a will that said, after my husband dies, let's say he survives me, after he dies, I want this property to go to all 5 children. Does her will control that property? No, she didn't sever the joint tenancy. Property would have had to be taken out of joint tenancy for her will to have any effect. And how do you sever joint tenancy? Under California law, even one joint tenant can cut it. You see the picture of my guy cutting the cement? Well, one joint tenant can sever joint tenancy by signing a deed saying, I am severing the joint tenancy. And then that person owns their 1/2 and their will does control where it goes. So in this case, the husband said, it's in joint tenancy. I'm filing an affidavit of death of joint tenant. I'm changing my trust to leave it to only to my children, not to her children of the prior marriage. That's what he did. And the court said, wife, you didn't sever the joint tenancy effectively.
All right, gosh, all these changes to trust and how to do them. I think if you remember, like last year, a few years ago, there was a case where there was a Post-it note attached to a document and it said, I want to leave everything to this one person. Was that enough to be a change to a trust? We're still dealing with this. We've had our laws for decades and decades, and still every year we have a case about, did somebody properly change a trust? So in a way, I guess it's a testament to say, work with your estate planning attorney to do it right. But here's what could happen if you don't do it right. And so in this case, the client had her estate plan set up by an attorney. And then a few years later, she wanted to make some changes to it. And so she spoke with the attorney, I think over the phone. The attorney drafted the change and then sent it back to her. And the client just signed it, which again, normally we would say, let's come into the office, let's review it together, sign it in front of us, we'll notarize it for you. And now you've done a very good, effective amendment to your trust. But in this case, the client just signed it and sent it back. Wasn't notarized. Was that going to be a problem? And in this case, that's what it all came down to, is that the document was never notarized. And so many times people think, everything has to be notarized because that's just what we do. And in this case, the court actually held, no, the fact that it wasn't notarized is fine. Under California law, the default probate code says The way to make a change to a trust, a modification or an amendment to the trust, is just that the trustee and the creator of the trust sign it, and then the creator of the trust signs it, delivers it to the trustee. Well, commonly, you are the trustee of your own trust. So the second you signed it, you also delivered it to yourself. So here's our picture, signed, sealed, delivered, not notarized. That was okay. So the amendment was found to be effective. And it would have been nice if all the client did was get it notarized, and then they wouldn't have to have the family go to court and figure out all these issues. And so it still kind of puts our California law kind of in this sort of a jeopardized kind of status quo, because for the future, we can't say automatically that every trust will just allow somebody to sign it without being notarized. Could still cause litigation to occur. And so the trust could say there's an exclusive way to make changes where it has to be signed and notarized. But again, many estate plans will typically just say that the trustor, the creator, signs it, gives it to the trustee, and that's fine. But commonly we would say, let's rely on a notarized document for any formal changes to the trust.
Trustee alert, my new favorite category. In the case of Strojan, this was a case that showed trustees what they should never do. It was like a recipe for don't do this. So let's take a look at what happened in the estate and why there was a conflict of interest. If you're the trustee of a trust for somebody else, you have a duty to protect the trust, protect the beneficiaries. You are not there to make a profit for yourself. You can be compensated for your services. That's it. So what did the trustee do in this case? The trustee personally borrowed money out of the trust. Major no-no. You can't be borrowing money. Did not provide any security for the loan, didn't pay their loan for years and years, and then leased trust property personally. It was actually cattle ranch property. And although paid rent, I don't think it was fair market rent, didn't distribute the rent to the beneficiaries for years. I mean, this trustee was using this trust as their personal piggy bank. What did the court do? The trustee was removed. You are no longer trustee. You get no trustee fees. You didn't act competently. And what really hurts trustees, this went to court and the trustee was not allowed to use trust funds to pay the trustee's attorney's fees because the trustee was not acting for the benefit of the trust. The trustee was personally liable for their own attorney's fees, it can be a huge amount. So trustees, you gotta be squeaky clean. That's what I tell people. Keep your accountings. You've got to make everything balanced to the penny. If you have any question that what you're doing might be challenged later, we can send out a notice to the beneficiaries that a certain action is about to happen. It could be the sale at a certain price to a certain buyer, all kinds of things. We notify beneficiaries early, get those accountings out to start the statute of limitations. Don't do what they did in Strojan.
Okay, and we're getting towards the end of the presentation. So if you wanted to still ask questions, go ahead and use the Q&A box and we'll go through the questions after the presentation. And of course, if you want to send us any emails, our email addresses will be up at the slides as well. All right, next, oh gosh, we're tackling financial elder abuse. And this is the Kading versus Kading case. And I think just like we mentioned earlier, again, elder abuse and kind of being taken advantage of as a senior can come in all forms. It doesn't have to be, a caregiver or door-to-door salesman or somebody that's taken advantage of you. It could be a family member or their children. And so initially in this case, dad was going to leave everything equally between his two children. And, one of the kids became estranged from the family and the dad changed the documents to say, okay, how about it'll be like an 80-20 split. And then the estranged child came back into the dad's life and then he was going to make it 50-50 again. Well, the child that was going to get the 80% didn't like the idea of having a 50-50 split. And so he tried to essentially take all the assets while dad was still alive, or make dad keep the trust to say, nope, it's going to be 80-20. And so the son went to some pretty extreme lengths in this case to try to keep all the assets for himself. One, he actually had dad sign a document saying, I'm not being taken advantage of, I have capacity. Well, that's like having like a hostage video saying, I'm fine, don't worry about it. That's already a red flag. And then he, informally went and had dad sign a power of attorney, giving the son the right to, sign on financial documents for himself, on dad's behalf. And using the power of attorney, he actually transferred the house to himself and the dad as joint tenants. As we mentioned earlier, that way it's not a part of the trust, it's not part of the 50-50 or 80-20 split. It just belongs 100% to the survivor, which would have been the son in this case, and even transfer some assets to the son, essentially taking everything out of the trust. Well, this was a pretty clear situation where son was taking advantage of dad. And the point of this is to say, not only did the son have to, give it all back in a way, but he was also sued for double damages. So the daughter said, you did all of this, you were acting very poorly, and not only do you have to put it all back, but whatever the damages are to the estate, you have to, from your own personal funds, put that amount back into it. So it's something to highlight that, it's not like you have nothing to lose when you do these types of things, is that the court has a way to issue double damages, and even sometimes triple damages. We call it treble damages if somebody was acting very, very wrong. So again, the takeaway is really be careful who you name as your trustee or your fiduciary. Sometimes they're going to have a lot of power to manage your assets. And many times people say, even if they trust their children, they just want to have somebody else. There are professional fiduciaries that exist. So there's a whole career field out there where people are licensed and insured and certified by the state to become your trustee. And again, they're not going to do any of these negligent actions. They're just going to do whatever the trust says, whatever's in your best interest. Again, they take a fee, but you can see what happens if you just try to have the family members do it, and it's a poorly run job. So that's something to be aware of.
Well, now we're at the end of our presentation, and maybe your brain is full. That's what people tell me. My brain is full. Look at that cloud. It's just so many ideas. Well, what are the takeaways from this presentation? In the estate tax arena, we know the exemption is going down in 20. To the survivor who may need it in the future. My new category that I love, trustee alerts. That's a big thing of what we talked about today. Be sure to pay taxes before you do a distribution. Look out for those lifetime gifts. If you're managing a charitable trust, you may have a new duty to notify the Attorney General. And the big sleeper that I think we're going to see cases starting, this coming year, if the trustor is incapacitated, trustees, you now have a duty to notify the beneficiaries. And the big no-no, that's always been the big no-no, if you're a trustee, you cannot have any self-dealing with the trust. As a grandmother, because whoever talks about how many grandchildren they have, well, I do now. Think about educating the next generation. And consider the 529 college plans. The big thing is saving money now for a need that's going to occur 18 years from now. You have the benefit of time and compound interest, and even small amounts saved now could wind up being a large amount by the time it's time for college. Property taxes, Prop 19. Ooh, we have to think about California real estate being transferred to children. What are we going to do about property taxes? Retirement plans, check your beneficiaries, and preventing undue influence. That's hard. And I'll just say from experience, I find that people who stay in touch with their family are less likely to be unduly influenced by, caretakers and neighbors and kind of bad people that might come into their life. So stay in touch with your family, stay in touch with your estate planning attorney who's known you from before and wants to protect you. So Daniel, are we going to switch over to questions now?
Yeah, so again, we appreciate everyone for hanging on this long. I know it's a long time to be on a Zoom conference, but we're gonna stay on, take some questions. If you have to log off, that's fine. And everyone will have received the handout that came along with this and an email along with the slides. So you'll be able to, download it, forward it to your friends afterwards. So thank you very much. And now let me go through some of these questions that we received. So one of them, Roberta, has to do with the gifts. So if I've already gifted, $15,000 for 5 years, all in 1 year, can I add the additional $1,000 onto those gifts in a 529 plan?
Very creative. No, you can't do that. So you have to use the law that's in effect in the year of the gift. So way back when, we could only make $10,000 gifts. That was the law. And if that's what you did in that year, done. And then we look to the next year and the next year. So if I made a $15,000 gift last year, that's all I could give. I cannot go back in time and add another $1,000. I have to deal with the law in effect on the date of the gift.
Yeah. Let's see, more property tax issues. So one, if you're an only child, do you even care about Prop 19? And so again, we tell our clients, you may not need to plan around it. It's just important to know. So we'll talk with our client to say, even if your house, you have one house, one child, the house is going to the child, we'll say, okay, that's what's going to happen. If the child lives there, they can keep the property taxes the same. If they don't live there, property taxes will go up. And even some wrinkles to the rule, if they live there, property taxes are the same while they're living there. If they later move out, property taxes go up, even if they don't sell it. So it's a pretty strict rule. So it is something that we talk to all of our clients about.
And may I add something to that? From a practical point of view, some parents think, because you had a picture of a nice mansion in your handout there, Daniel, and a question arises as to whether a child would really even want to live there, and how much does it cost to live there in terms of maintaining the property, which could be large gardening bills, could be a new roof and what have you. And there's been a change in the generations. So this is the benefit of having multi-generational lawyers, where one generation, I'm going to represent the baby boomers, might have thought that having a very luxurious home is one of their goals. The next generation may not think that that is a goal whatsoever. It's a new generation completely. And even when you go into your grandchildren's generation, what are their values? So it's important to have these discussions and to even create a budget of what does it cost to live in that house?
Yeah. Still, again, always a big deal to talk about property taxes. We're in Southern California, so it's not a surprise. What about when a child inherits a property and then it's been rented for many years and then they sell the property? What happens with the basis and depreciation? What do you think?
All right, so at the point of a death, because that child inherited the property, the value on date of death becomes the new income tax basis. Lots of times I have executors and trustees, they want to go back in time and find out all the improvements that were made before death. They want to add that into basis. They want to think about depreciation. And I say, hold on, you don't even have to think about that. You need to get a valuation on date of death. And they're starting to think, oh, if I get a high valuation, that's going to be my new income tax basis. And I tell them as a lawyer, you have to get a reasonable valuation. It needs to be supported by comparable sales from around that point in time. And we know that real estate has really skyrocketed this year. So sometimes, what was the value on the date of death? That's a good question. Are they going back to comparables from 6 months ago that kind of don't apply? So valuation itself is an art. Now, let's say that property is rented. So now the new basis is going to be raised by improvements lowered by depreciation. And when they finally sell, they're going to take that current basis as it's been adjusted to compute capital gain.
Yeah. And another question about Prop 19. Did it remove the 2% cap on the annual real estate tax increase? It did not. So we're living with Prop 13 and Prop 19. So right, Prop 13 limits how much your property taxes can increase every year, which in this case, again, is that 2% amount per year. So even if your house doubles in 1 year, property taxes can only go up a certain amount. But with Prop 19, now we're thinking, what about when a child inherits a property from a parent? Specific to that, what happens with property taxes? Prop 19 also has some other changes, like if you're 55 and older and you want to buy a substitute property, about keeping the property taxes the same. So there are other things to think about when we talk about Prop 19. But as estate planners, we mostly focus on what happens when you either transfer in your lifetime a property to a child or they inherit it at death. And let's see, we had a question about, so if you move to another state, we always recommend have an attorney in that state review the estate plan. So every state, of our 50 states has different rules, and sometimes they can be very different than California. The biggest one we talk about is that we're a community property state. And I think there's only like 13 states that are community property states. That the way we do estate planning is going to be very different than a non-community property state for a married couple. Let's see, a question about 529 plans. So if you paid tuition directly to the college and didn't use the funds in the 529, what happens if there's some money left over in those 529 plans?
You think I know the answer to that question? Is that why you gave it to me?
No, I'm just reading aloud. So right, 529 plans, one, check with the financial advisor if you have one that's helping you with that, but they can be transferred among siblings and within certain generations of you. And I think even you can use it for yourself if you want to take some adult classes at the or classes at the adult college kind of thing, pay for it that way. But there's really laid out rules specifically on how the funds can be used. And I think it can even go to cousins, I believe. And let's see. Yeah, a great question that has to deal with, what about having a will and a trust? So it's kind of one of the most common questions we get in setting up an estate plan is why do you have both? How does it work? So the trust will control all the assets that are titled in the name of the trust at the time of your death. So let's say you set up your estate plan and we put your house titled in the name of the trust. The trust will control it, which is great. Doesn't go through probate, passes according to the terms of the trust. What if we set up the estate plan, you have your will in the trust, the house is in the trust, but later on you buy another house and you just buy it in your name. It's not titled in the name of the trust. The trust doesn't control that house at the time of your death. It's part of your estate, which is, we look to the will. What happens to your estate? The will likely will say it goes into the trust. So commonly we call it a pour over will. It pours over everything from your estate into the trust. The problem would be it may have to go through probate to get into the trust, which we always want to avoid. That's the big deal, is we want to avoid probate. And so they essentially will the assets will be managed according to how they're titled, whether it's in the trust or whether it passes through the will as part of your estate. Let's see. And I think we'll leave it for there since it's 11:30. Don't want to hold you much longer. And so we're going to head and end the presentation. But again, you have our contact information. You can always email us with questions. And if you feel like anything we've talked about makes you want to come in to us, make some changes or talk about it, let us know and we'll get down and go over your specific estate plan. And that way we can continue helping you out for many years to come. And thank you all for joining us for the presentation today.
Thank you.